Hello, my name is Clem, or Clem Chartier. I just want to say that after the First Ministers' conferences in the 1980s, there was 4 of them, then we had the Charlottetown round, the last one, the 5th and last one, where we tried to get more rights for the Métis and other Indigenous peoples into Canada's Constitution. We failed. Since that time, our leaders have said, well, let's turn to the courts. Let's turn to Section 35 and start defending our people when they get charged with hunting or fishing without a license, because we believe that we have the rights to do that. So in 1993, the late Senator Louis Morin approached myself and Philip Chartier, the president of the Buffalo Narrows Métis Local, to defend one of the citizens, Toby Snowman Mogra from Turner Lake, who had been charged with hunting without a license and also hunting in the road corridor. And we agreed, because Louis said, look, Clem, you're a lawyer, you should defend our people. And I said, yes, I'd be pleased to do that. So working with the local, we did do that defense, but we know we couldn't win because it was in a road corridor. But the judge, at the end of the day, rather than a $200 fine, which was on the ticket, just gave $50, which is like a little slap on the fingers, because he realized after I spoke for about 20 minutes on what script did to our people that it wasn't right to convict a traditional resource user for harvesting a moose, because none of our people drive by a moose when you can harvest it for your family. But in any event, that was the first case. Then we did the Morin and Dion case, again out of Turner Lake, with Louis Morin saying, look, we've got to defend these young people. It's their livelihood. So in 1995, we went to trial in Buffalo Narrows for 4 days, and Jean Taillet, who was an articling student in Toronto, joined me there for the week. And in August of 1996, the provincial court said, whatever land script did to land, which it did not have to decide, it did not extinguish the fishing right, because there was nothing in any of the documents or the legislation that said, by taking script, you're giving up your hunting and fishing rights. And that was taken to the Court of Queen's Bench, and in 1997, the Court of Queen's Bench upheld that decision, and since then, the Métis in Northwest Saskatchewan have been able to hunt and fish without a license. We also, at the same time, did the Grumbo case out of Yorkton, and for 2 years, Métis throughout the province were able to hunt and fish without a license on the fact, or based on the fact or interpretation that paragraph 12 of the 1930 transfer agreement, which was where the federal government transferred almost all of the Crown lands to the province in Saskatchewan, also in Manitoba and Alberta. And paragraph 12 stated that the province guarantees the Indians the right to hunt, trap, and fish for food at all seasons of the year on all unoccupied Crown lands or lands they have a right of access to. However, in 1998, the Saskatchewan Court of Appeal sent it back for more information, and unfortunately, the Crown stayed the case. In other words, they abandoned the case, as they did for a similar one, the La Liberty case, the late Isidore La Liberty in Green Lake. So that one has stayed as well. So we've never had a chance to look at that. But on that, in 2003, the Supreme Court of Canada, when it dealt with the Powley case, where it says here are the conditions you have to meet to establish a Métis right. At that same time, they did the Blake case, where they said Métis did not fall within paragraph 12, the term Indian in paragraph 12 of 1930. So since then, we haven't been able to access that one. The foundation, which I'm the chair of, was established in 2001 to continue the pro bono or free legal work to defend our people, primarily in Northwest Saskatchewan, but throughout the rest of Saskatchewan as well. For example, Michelle Leclerc joined me in defending Ron Bellimer, who was charged with fishing without a license at Lebret in the early 2000s. And we went to trial, and in 2007, the provincial court stated that the Métis in the Qu'Appelle Valley and environs, including the city of Regina, have the right to fish without a license, which extends to hunting without a license. It was appealed, but a number of years later, the Crown dropped that appeal, so that's a standing decision for southern Saskatchewan. Again, the local through the Métis Rights Defense Fund, basically paid for the costs of that case. So again, a very important case for the Métis in southern Saskatchewan. And since then, working with Kathy Hodgson-Smith, we've defended a number of other cases out of Meadow Lake, and two of them are currently going to the Saskatchewan Court of Appeal, the Boyer case and the Putra case. And also, Kathy does have, and she's not with the foundation, but she does have a case that she's doing pro bono out of Yorkton, the Harold St. Pierre hunting case. So a number of these cases are in place, and we've felt as lawyers, and I should mention that Dwayne Roth, out of former president of the MNS, now living in Alberta, also joined us in the Mayette, Putra, and Boyer cases at trial, and in fact the Mayette case was resolved. Mayette was found to have the right to hunt where he did, which was between Meadow Lake and Green Lake. Mr. Boyer was fishing at Chittick Lake, and the Crown says, or the judge said, while he has an ancestral connection to Northwest Saskatchewan and a contemporary connection, there was no evidence that the village of Chittick Lake was established prior to the date of effective control. So he lost, same as Putra, while he was born in Meadow Lake. The court did say that yes, he has a historic connection, a contemporary connection, but there was no evidence that the Métis of Northwest Saskatchewan hunted 37 kilometers south of Meadow Lake at Elcock Creek. So we've appealed that to Queen's Bench. We lost there. Now we're appealing to the Saskatchewan Court of Appeal, and likely it will be heard later this fall or early next year. So the foundation continues to do that, and we will continue to do that. It's very important for us to, in fact, establish these hunting and fishing rights for our people throughout the province. And as the old saying goes, we can't feed everybody, but we can at least give the people the means to feed themselves. In this case, the right to hunt and fish without fear, without having to hide and hunt at night, not having to sneak your meat and your fish back to your communities. While it's not province-wide yet, that is still an objective that the foundation is working on, and we're hopeful that as we move forward that we can eventually get to that point in time where all Métis within the province of Saskatchewan can exercise their legitimate rights to hunt and fish to feed their families. Thank you.